Good evening, class. Tonight's topic, Chapter 6, Rescissible Contracts. So, again, rescissible contracts, katulad ng sinabi ko sa introduction, rescissible contracts are one of the defective contracts. So, in decreasing effectivity or effectiveness, remember, nauuna ang rescissible contracts. Siyempre, ang pinakauna talaga is a valid contract. Tapos, pagkatapos ng valid contract, yung mga defective contracts. And among all the defective contracts, rescissible contracts yung pinaka may force and effect. So, again, rescissible. After that, we have voidable contracts. Also, after voidable contracts, unenforceable. And the last one, yung wala talagang force and effect, yung mga void contracts. So, in Chapter 6, we will learn first the definition of a rescissible contract. So again, a rescissible contract is defined under 1380. Ano ang sabi sa 1380? Rescissible contracts are valid contracts. They are enforceable. So the parties, they have rights and obligations under a rescissible contract. Bakit siya valid contract? Because all the essential elements exist. But remember, class, in case of economic damage or economic prejudice or lesion on the part of one of the parties, the law grants the remedy of rescission. Dahil merong defect, merong pagiging unfair yung contract na rescissible. So, remember, in a rescissible contract, wala naman talagang defect, except na meron lang siyang economic damage or economic prejudice. That's why the law will grant the remedy of rescission. So, yun ang una nating tandaan. The kinds of rescissible contracts, they are found in Article 1381. And also later on, you will notice that some other provisions in the Civil Code are also talk about rescissible contracts. So, the first one is contracts entered into in behalf of wards. So remember, in paragraph 1, you have to learn to identify the following. Sino ba ang ward? Sino ba ang guardian? So ang isang guardian is a person na who is in charge of the ward. So remember, ang guardian, ang binabantayan niyan, ang ward niya, obviously, is somebody who is incapacitated. So, ang mga wards, incapacitated yan, either by minority or by insanity, by a medical condition, etc., etc. And the person who is appointed to look after the ward is called your guardian. So, in number 1, paragraph 1, 1381, the person who enters into the contract is not the incapacitated person. So, let's take, for example, our incapacitated person or our ward is a minor. So remember, it is not the minor who will enter into a contract in 1381 paragraph 1. But the person who will enter into the contract is the guardian of the ward. And remember, when the guardian of the ward, parang hindi na mahirap, when the guardian entered into the contract with a third person, it involves property of the ward. So, yun ang tandaan nyo. Guardian will enter into a contract with a third person and yung contract involves property of the ward. And what else? What will make it rescissible? Economic damage or lesion of more than 1/4 the value of the property of the minor. So, kung nalugi yung minor ng more than 1/4 ng value ng kanyang property, so let us say, class, ang property ng ward is worth 100,000 pesos. So yun ang kanyang property. Binenta ito ng guardian. Remember, class, it is not again the ward who will enter into the contract, but it is the guardian who enters into the contract. So guardian, property of the ward, guardian sells property to a third person. The real value of the property, let us say, is 100,000 pesos. But the guardian sells it for 50,000 pesos. Now, question, class, is the contract rescissible? Ay, ako rin pala sasagot. Of course, class, the contract is rescissible. Bakit? Because there is lesson. Nalugi si minor. Magkano nilugi niya? 50% of the value. The value of his land is supposed to be how much? 100,000. Magkano lang ang pagkakabenta? Only 50,000. Because the minor suffered a lesson. Remember, when the minor reaches the age of majority or legal age, the minor can ask for rescission of the contract. But as you can see, there's no defect in the contract. Cause object consent, wala namang sinabing defective doon sa contract. Except that the price is inadequate or there is lesson. So remember here that the contract entered into by the guardian is a rescissible contract. Now what if, same problem, property of the ward worth 100,000 pesos, pero ibinenta ng 750,000. So, 1 million pala. Yan, 1 million ang property ng ward, binenta ng 750,000 pesos. Now, question, is the contract rescissible? So, the answer is, remember, the contract is not rescissible. Bakit? Ano ang sabi ng law? The lesson must be more than 1/4 the value of the property of the ward. So, here, in my example, 1 million property, 750 na benta, 750K na benta, the lesson there is exactly 1/4. That is why the contract is not rescissible. So obviously, kung nabenta ng 800, 900, yes, there is lesson. It is inadequately sold by the guardian. But this is not a rescissible contract. Kasi sabi ng law, lesson must be more than 1/4 the value of the property. Same is true in case of, let us say, may pera ang ward, tapos gusto niya ng kotse. So, ito namang si guardian, pinambili niya ng kotse yung ward, yung minor. Tapos, yung halaga ng kotse, sa totoo lang, is only 100,000. Pero nung binili ng guardian, nakipagkontsaba siya dun sa seller, na instead na bibilin ng guardian for its real value, which is 100,000, binili ni guardian ng 190,000. Yan, halos doble ang presyo. So here, siguro merong kickback yung guardian or whatever, but here, remember, the contract is rescissible. Bakit? Because the economic damage or lesson suffered by the ward is more than 1/4 of the value of the property. Kung nabili niya ng 120, 125, walang lesson yon because that is 1/4 or less of the value of the property. But remember, if it is sold for, let us say, 126,000, ganyan, or 125,100, more than 1/4 the value of the property, there is already a lesson. So this is rescissible at the instance of the ward when he gains capacity. So kung minor, when he gains capacity, pagka naman incapacitated or insane, etc., when they gain capacity. What else? Number 2, contracts agreed upon in representation of absentees, or paragraph 2 of Article 1381. So remember, in paragraph 2 of Article 1381, the same rule applies. So you have to learn first kung ano yung absentee. So an absentee is a person who is absent from his domicile. So yung domicile is your habitual residence, kung saan ka nakatira, and kung umalis ka doon, you have the intention of coming back. That is known as your domicile. Now, in paragraph 2, remember na yung tao na may property, absent siya. So, he cannot be located. And remember here that somebody will ask to be appointed as his representative. So, yung representative ng absentee is the one who will enter into the contract, not the absentee. Bakit? Absent nga siya. How can he enter into a contract? So remember, it is the representative of the absentee who will enter into the contract, and it involves the property of the absentee. And also in paragraph 2, the absentee will suffer lesion of more than 1/4 the value of his property. Now, who can ask for rescission of this contract? The absentee upon his return. So, pagka bumalik na siya, hindi na siya absent, present na siya, he can ask for rescission of this contract. So, the third rescissible contracts are contracts entered into in fraud of creditors. So, we already discussed this in relativity principle. Remember, yung action Pollyanna. So, in action Pollyanna, there is a debtor, there is a creditor. And remember, yung debtor may utang sa creditor na, let us say, 1 million. Tapos, ito namang si debtor, kahit na meron siyang utang kay creditor, hindi siya nagbabayad. Pero itong si debtor, meron siyang property. Let us say, it is a parcel of land. The parcel of land is also worth 1 million. Nung sinisingil na ni creditor si debtor, imbis na magbayad si debtor kay creditor, pwede naman niyang gawing pera yung lupa niya. Pwede niyang ibenta sa iba for the same price. Pero anong ginawa ni debtor? Instead of selling his property to a third person for the amount na kung ano yung value niya, ibinenta ni debtor yung lupa niya na worth 1 million for, let us say, 50,000 only dun sa kanyang anak. So, remember here, ito yung usually tinatawag nating action Pollyanna. Now, here, debtor, may utang siya kay creditor, 1 million, meron siyang lupa, tapos 1 million din ang halaga, ibinenta niya kay son instead of paying the creditor yung 1 million. So, here in number 3, this is what you call action Pollyanna. Kung ikaw si C na creditor, ano ang remedy mo? Kasi sinisingil mo si D, wala na siyang pera. Tapos yung nag-iisa niyang pwedeng pagmulan ng pera niya, ibinenta pa niya ng palugi sa kanyang anak. Now, if you are C, what will you do? You can ask for rescission of what contract? Of course, not the contract with the debtor. Hindi mo ipaparescind yung kontrata ng utang ng debtor sa'yo. But you will ask for rescission of the contract between the debtor and the son. So, yun ang ipaparescind mo. So, remember, ask for the rescission of this contract, not this one. Because remember, this contract is undertaken to defraud you as the creditor. So, this is an exception to relativity. Why? Because itong si C, remember C is a part of the contract between debtor and creditor. Pero dito sa example natin, may pangalawang contract. The contract of sale between the debtor and the son. Itong si C is not a part of the contract between debtor and the son. But remember, C can ask for rescission of the sale of the parcel of land from debtor to son. Why? Because it is a rescissible contract, number 1. And number 2, because it is undertaken in fraud of creditors. Kaya lang naman binenta ni debtor yan kay son kasi gusto niyang lokohin si creditor para wala nga namang makuha si creditor para lumabas siyang insolvent. So remember, that is the third rescissible contract. Yun namang susunod, contracts which refer to things under litigation. So, things under litigation, ito yung ito yung mga object na meron ng demanda, tapos it is already in the custody of the court. So, meron akong nabiling lupa, tapos may naghahabol dun sa binili kong lupa. Apparently, siya daw ang totoong may-ari. So, dinimanda niya ako kasi he wants to recover yung lupa na nabili ko. So, nung dinimanda niya ako, natanggap ko na yung sulat galing sa court. Tapos, yung property is already under litigation. Kasi nga, natanggap ko na yung sulat na galing sa court, meron ng jurisdiction ang court sa pagkatao ko. So, itong property na to, because it is under litigation, it is already in the custody of the court, I am not allowed to sell it or to dispose of that property. Now, kung binenta ko yung property na yan, yung naghahabol sa akin, kung nanalo siya sa case namin, he can ask for rescission of my sale to my buyer. Bakit? Kasi again, rescissible contract yon. The property is already under litigation, pero ibinenta ko pa rin. So, this is again one type of rescissible contract. What else? Other instances, marami yan. So, other instances will refer to Article 1098 in case of partition of mana between heirs. If one of the heirs suffers lesion of more than 1/4 of the value of his inheritance. 1189, deterioration through the fault of the debtor. So, ito ay rescissible contract pa rin. 1191, violation of contract by one party in reciprocal obligations, etc., etc. Marami yan actually. Usually, itong 1526, 1534, this will all refer to your law on sales. 1539, 1542, puro law on sales yung mga yan. So, ito yung mga sales na rescissible. So, anyway, nandiyan yung mga provisions. Tignan nyo na lamang para hindi na tayo pare-parehong mahirapan. Usually, because there is a lack of the area in a sale or there are breaches of warranties, kaya nagiging rescissible ang mga contract na yan. So, yun ang 5 klase ng rescissible contracts, although yung other instances, marami sila. What else? Also, remember in relation to this, contracts approved by the courts. Medyo nabigla ako dito, sandali lang. I will move my lecture. So, contracts approved by the courts, this will refer to the contracts entered into by guardians or those entered into by representative of absentees. If remember, that contract is court approved, yung contract in paragraph 1, 1381, and paragraph 2, 1381, if the sale is approved by the court, even if there is lesion, the sale is not rescissible. Dahil nga naman, the law will presume that the courts are working or parang protecting the rights of the ward and also of the absentee. That's why if the contract is approved by the court, even if there is lesion or inadequacy of the price, and also there is no showing that there can be a better price, the contract is not rescissible. So, 1386, so that is, remember, a qualification or modification of the rule in paragraphs 1 and 2 of 1381. What else? 1385, gusto ko sanang 1382, gusto ko sanang isama sa rescissible contracts ito pero technically in 1382 we are not talking about a contract, but we are talking about a payment. So in 1382, the payment is made in a state of insolvency. Insolvent ka na, pero nagbayad ka. Anong mali doon? May utang ka naman, dapat kang magbayad. What is wrong in 1382 is that when the payment is made, it is not yet due and demandable. Or, it is no longer demandable at all. Meaning, nag-prescribe na yung obligation. So, let us say may utang ako sa yung 1 million, may utang ako sa ibang tao, tigwa 1 million, 10 kayo. Sa lahat ng utang, yung sayo na lang ang hindi due and demandable. Yung lahat ng ibang utang ko, already due and demandable, hinahabol na ako ng lahat ng creditors. Meron akong last pera, 1 million. Hulaan nyo sa 10 creditors ko, hulaan nyo kung sinong binayaran ko. Ikaw, na hindi pa due and demandable yung utang ko sa'yo. So, here, remember, pwedeng iparescind ito ng mga ibang creditors. Because when I paid you, and I was already insolvent, my obligation to you is not yet due and demandable. Same is true if my obligation is no longer demandable when it has prescribed. 20 years na yung utang ko sa'yo, hindi pa ako naniningil, nag-prescribe na yon kasi 10 years na, pwede na mag-prescribe eh. So remember, sa lahat ng pinagkakautangan ko, ikaw pang binayaran ko kung ano yung utang ko na prescribed na. Again, my other creditors can ask for rescission of that payment. What else? An action for rescission covered by Article 1383 and 1384. In 1384, remember, ang sabi ng law, rescission is not a principal remedy. So, ang kailangan yung tandaan sa 1383, if you can avail of other remedies, avail of that remedy first. Rescission is available only when there is no other choice. Kung walang-wala na talagang ibang remedy, dun lang pwede yung rescission. So, if you can get your money's worth, let us say, dun sa case ng number 1, in case of a minor na nalugi dun sa pagbebenta ng lupa niya. Now, remember, if the buyer of the land of the minor wants to add doon sa purchase price, pwede yon. No need to ask for rescission kasi he can recover yung loss or lesson in some other manner. Basta last choice ang rescission. Kumbaga sa prom, ito yung babae na walang nagyayaya na maging date siya. Siya yung pinaka-last. Or yung walang nagyayayang sumayaw, ito siya. Siya yung rescission. So, yun ang tandaan nyo sa 1383. In 1384, rescission is only to the extent that is necessary to cover the damages caused. Usually, the example here is 2 parcels of land, binenta ng 200,000 yung dalawa, pero sa totoo lang, bawat isa nun 200,000 na. So, kailangan mo bang i-rescind yung sale ng dalawang parcel of land? Not necessarily. If you rescind the sale of one, pwede na yon, maayos na yung, there is no economic damage already. So, only to the extent that is necessary to cover the damages caused. Pagka ni-rescind na yung isa, nasolusyonan na, natakpan na yung lesson. So, hanggang ganun lang ang i-rescind. What else? Also, remember, 1385, rescission creates the obligation of mutual restitution. So, ano ba yung mutual restitution? Ito yung pagbabalikan ng mga gamit. Parang pagka nag-break kayo ng boyfriend mo, tapos matagal na kayong break, tapos nag-usap kayo na magkikita kayo one day lang para lang ibalik yung mga gamit na binigay nyo sa isa't isa. Merong mga ganung drama yung mga kabataan ngayon, pero sa totoo lang hindi ko gets talaga yung point noon. Bakit mo pa ibabalik? Hindi naman niya papakinabangan. At saka ano naman ang mafe-feel mo kung halimbawa yung binalik mong damit, nakita mo nandun sa bago niyang girlfriend. Diba? Anong point noon? Tapos nagpapapicture pa, etc. etc. So, pero sa law, kailangan daw ng mutual restitution. So, kung ano ang natanggap ng buyer, kailangan niyang ibalik. Let us say, ang natanggap ng buyer is a parcel of land. He has to return the parcel of land. And ito namang si seller, kailangan niyang ibalik yung pera ng buyer. So, it creates an obligation of mutual restitution or balikan ng mga natanggap mo under the contract. So, bakit mayroong mutual restitution? To return the parties to the status quo or to their original situation. So, the rule of mutual restitution even applies to third persons. So, as you will learn later on when we go to the last provision for this chapter 1388, the second to the last provision in this chapter. Please take note also that rescission is not allowed in 2 cases. Number 1, if you are the party demanding for rescission and you cannot return the object or what you are obliged to restore under the contract, hindi ka pwedeng mag-ask for rescission kasi hindi mo kayang magbalik. And the last one, if the third person who is in possession of the property is in good faith or hindi niya alam na mayroong defect or economic prejudice that was suffered by the original owner of the property. So remember, it applies to third persons, but there are also exceptions. What else? Also, in addition to that, the period for filing of an action for rescission under 1389. So remember, in 1389, the general rule is that an action for rescission may be filed within 4 years from the date of the contract. That is the general rule. But obviously, for every general rule, we have, again, exceptions. So the exceptions are, number 1, for persons under guardianship, as in paragraph 1, the 4-year period shall begin from the termination of incapacity. So, usually, sa guardianship, lalong-lalo na kung minor, for minors, guardianship will end at the time of attainment of legal age. So, pagka nag-18 na, meron siyang hanggang 22 years old to file an action for rescission of the contract entered into by the guardian. Same is true with insane persons. From the time na makuha nila yung kanilang capacity, they have 4 years to file an action for rescission. What else? For absentees, in paragraph 2, 1381, from the time that the domicile is known. Pagka limitaw na sila, they have 4 years to file an action for rescission. So what else? Also, in addition to that, persons who are allowed to bring an action for rescission, injured party or the defrauded creditor. Injured party in case of 1381, paragraph 1 and 2, and also defrauded creditor in case of paragraph 3, and also in case of payments made in a state of insolvency. What else? Heirs, assigns, or successors in interest can also bring an action for rescission. What else? The creditors of the above entitled to subrogation. So again, remember, subrogation is yung pagpapalit ng creditor. So what else? Badges of fraud, very important. So before we discuss badges of fraud, we have first to discuss when an alienation is presumed to be in fraud of creditors. So an alienation may refer to a sale, may refer to a donation. Basta dinidispose nyo yung property nyo, it is known as an alienation. So, in 1387, nagbibigay siya ng mga instances where the alienation is presumed to be in fraud of creditors. Kaya mo ibinenta kasi gusto mong lokohin yung mga creditors mo. So, please take note that this is a prima facie presumption of fraud, but the enumeration is not exclusive. Remember the rules in case of gratuitous alienations, meaning donations. Dinonate mo yung property mo. It is presumed fraudulent when the debtor did not reserve sufficient property to pay for all the debts before the donation. So, nag-donate ka ng property, tapos wala kang tinira sa sarili mo. Hindi mo nabayaran yung mga utang mo, tapos hindi ka nagtira sufficient for your own support. So, bakit ka nag-donate kung wala kang tinira para sa sarili mo bilang pambayad ng utang mo and at the same time, pang-support sa sarili mo? So, malamang-lamang yung donation na ginawa mo, hindi talaga siya totoo. Gusto mo lang lokohin yung mga creditors mo para wala siyang makuha sa inyo. So, here, remember, this is presumed to be a fraudulent, gratuitous alienation. What else? In case of onerous alienations, ito yung mga sales. So, in case of onerous alienation, it is presumed to be fraudulent when made by persons against whom some judgment has been rendered, even if it is not yet a final judgment. So, debtor, creditor, tapos yung debtor already na demanda, tapos meron na siyang liability, kumbaga napalitaw na nga na sa court na siya ay talagang may utang. So, some judgment has been rendered against this debtor. Ito namang debtor na to, alam na nga niyang meron na siyang liability, meron ng decision against him. Again, this debtor sells his property to a third person. Bakit niya kaya ibinenta? Alam naman niyang meron na siyang liability na kailangan niyang bayaran. Bakit pa siya nagbenta sa iba? So, um, this is an onerous alienation presumed to be in fraud of creditors. And number 2, when made by persons against whom some writ of attachment has been issued. A writ of attachment is a writ na sinasabing hinahawakan muna ng korte ang iyong property. So, hinahawakan na nga ng korte, the court wants to put it in its custody, pero anong ginawa mo? Even if your property is attached by the court, ibinenta mo pa rin. This is presumed to be an onerous alienation. Bakit mo ginagawa? Kasi gusto mong lokohin yung mga creditors mo. What else? Badges of fraud. Minsan, ito na yung proper. So, badges of fraud are circumstances that will indicate that the alienation, whether gratuitous or onerous, has been made in fraud of creditors. So, maraming badges of fraud. Number 1, if the consideration is fictitious or inadequate, binenta mo yung property mo, pero sobrang babang price. Bakit mo ginawa yun? Kasi baka fake yung sale, baka hindi naman totoong ibinenta mo. Baka gusto mo lang itago yung properties mo para hindi na makuha ng mga debtor ng mga creditor. So, what else? Number 2, transfer made by a debtor after suit has been begun and while it is pending. Nakademanda ka na, tas anong ginawa mo? Sinimulan mo nang ipagbebenta ang mga properties mo. Why are you doing it? Para later on, wala nang mahabol yung mga creditors mo. Ubus ka na, nailipat mo na lahat sa pangalan ng ibang tao. What else? Number 3, sale upon credit by an insolvent debtor. So, again, you're insolvent. Bakit ka magbebenta? On credit pa, hindi man lamang cash, insolvent ka nga, kailangan mo ng pera. So, what does it say about you? Maybe you're doing it just to defraud your creditors. What else? Letter D. Letter D, transfer of all or nearly all of the property of a debtor, especially when he is already insolvent or greatly embarrassed financially. So, again, ito yung in relation to the last one that I've already discussed. Nilipat na niya lahat, binenta na niya na lahat ng kanyang properties sa lahat ng kamag-anak niya. Bakit niya ginagawa yon? Para walang mahabol ang mga creditors. So, again, ito ay ginagawa para manloko, kaya siya ay tinatawag na badges. Siya ay kasama sa badges of fraud. They are circumstances to indicate that the transfer is fraudulent. And if napatunayan that the transfer is fraudulent, it can be rescinded by the creditor who is concerned. What else? Letter E, the transfer is made between father and son, and together with other circumstances, mababa ang price, etc. Idagdag mo yan, kasi hindi naman porke transfer from father to son, rescissible na kaagad. Sometimes kasi may legitimate. But, kung i-add mo yung mga ibang circumstances taken as a whole, remember, it may be fraudulent. But letter E, by itself, is not at all fraudulent. It does not follow. Pero sama mo yung iba, probably. Kasama ito sa circumstances indicating fraud. What else? Failure of the buyer to take possession of the property. Kung talagang ibinenta ito ng debtor sa kanyang buyer, bakit hindi nag-take possession ang buyer? Kasi hindi naman talaga totoo ang sale. So, maybe this sale is only undertaken to defraud yung creditors. What else? Buyer knows that the seller has no other properties other than kung ano yung binenta sa kanya. So, taken in relation to letter F. What else? A purchaser in bad faith, 1388. So, ang purchaser in bad faith is a person who will acquire from the debtor yung property na hinahabol ng creditor. Like in our example here, son can be considered a purchaser in bad faith if the son is aware na itong transfer from debtor to him is in fraud of creditors. So, siya ay considered a purchaser in bad faith. So, the liability of a purchaser in bad faith, ayan nga, nakalagay, who acquired the object of the contract alienated in fraud of creditors must return the same. So, this is the reason why even third persons are required to restore. So, the doctrine of mutual restitution applies to third person. Now, if it is impossible for him to return it, he must indemnify the creditor. But this is what is very important here. The purchaser must be in bad faith. Kung hindi naman niya alam tungkol dyan sa transaction, wala siyang kaalam-alam that the transaction, yung binenta sa kanya, yung pagbebenta sa kanya was done in fraud of creditors, this will not apply. What else? The effect of bad faith, the acquirer or yung nakabili must return or indemnify, return the property or indemnify the creditor. And even if the object is lost by a fortuitous event, nandyan pa rin yung obligation to restore or to return. Kasi nga, bad faith. What else? Also, what about subsequent transfers? Sandali lang, susulat ako ng konti. So, son transfers to X, a third person. So, here in my diagram, hindi kasi gumagamit, masyado kasi nagre-reflect yung whiteboard ko eh. Son transfers to a third person, X. Now, ito bang si X, can he be considered a purchaser in bad faith? If the son is in bad faith, X is also considered a purchaser in bad faith if alam niya yung tungkol sa fraudulent transaction na ito. Now, what if S or the son is in good faith? Ngayon, kung si son ay good faith, itong si X, whether or not bad faith siya or good faith siya, it does not matter. As long as yung first transfer is a legitimate transfer, pagka napunta na kay X yan, X is not required to restore. Kasi, na-cure na yung defect dito pa lang. What else? Number 2, if the first transferee is in bad faith, son is in bad faith, the next transferee is liable to restore if also in bad faith. So, tandaan nyo yung dalawa. So, bad faith to, tapos binili nito, bad faith din siya, X is obliged to restore. Now, if X is not in bad faith, obviously, hindi. Paano kung baliktad? Ito good faith, tapos ito bad faith, hindi na magre-restore to. Kasi, na-cure na yung defect dito parang sa part na to. So, what if good faith siya? Mas lalong hindi siya magre-restore. Good faith, mas lalong hindi magre-restore. So, what else? That's it pala. So, that is for rescissible contracts. Hindi ako makapaniwalang tapos na. So, anyway, our next topic will be Chapter 7, Voidable Contracts. Please wait for the next lecture. Thank you.